All rise. Court of Appeal for the Fifth District of the State of Florida is now in session. The Honorable Brian D. Lambert, Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. And God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Quickly, I close those curtains. All right. Good afternoon. Welcome to afternoon session of oral arguments at the 5th DCA. As our marshal has indicated, I am Judge Lambert. I am presiding this afternoon. Let me introduce the panel. To my right and your left is Judge Vincent Torpy. And to my left, your right, is Judge Dan Traver. He's an associate judge sitting with us today. He's previously sat with us before. He's a circuit judge in Orlando. He's happy to have him back with us and help us conclude these cases this afternoon. Couple things. If you happen to have any type of electronic device or phone or whatever, please either mute that or turn it off so that you're not disturbing any of the counsel when they're speaking. We have 4 cases this afternoon. The first 3 are consolidated for oral argument purposes, and they're traveling together and sharing the same record. And in that case, by earlier court order, the parties have agreed to 30 minutes to the appellant and 30 minutes to the collective appellees. I know on the first 2 cases, 17-1384 and 17-1606, it looks like it's the same appellee counsel. Ms. Rooney? Okay, and as to the third case, there's various appellees. Have you all worked out how you're going to divide your 30 minutes?
Yes, we have, Your Honor. I'm going to reserve 15 minutes for the first 2 cases, and my colleagues are each going to reserve 5 minutes apiece.
Okay. All right. Typically, we have 5 minutes rebuttal for the appellant. If you want to have some different amount of rebuttal time, let us know, and we'll be happy to oblige with that. That being said, if you're ready to go, counsel, you can go ahead and proceed.
I am. Thank you, Your Honor. May it please the court, David Baruch, on behalf of CBC Contractors, or CBC, I should say. I'd like to reserve 7 minutes for rebuttal, please.
All right. Good enough.
Thank you.
Can you highlight quickly for me as to the various subcontractors, just list the defects that are alleged and tell me what the evidence is on each of those defects? Let's start with Allen, if you would, sir.
Certainly. Your Honor, I would have to refer you back to the briefs and the citations there, to the record citations, and to start with Allen Steel, whose scope of work was a steel stair system. If you go back into the briefs, it references the Delta report that was completed for the association back in April of 2009, the ME construction report.
I mean, that's a 700-page report. I was hoping you could just distill it down to a list of what the defects are so I can understand what they are.
Certainly, Your Honor. For the steel stair system, and honestly, I do not have the list in front of me, but the defects are in the installation.
You don't have it memorized?
I do not, Your Honor.
Then hit the highlights for me.
Certainly,
Okay.
Your Honor. And this is...
I mean, the steel stairs rusted.
They did.
What's the defect on the steel stairs?
The defect was the installation, and I believe there were toppings as well that go on the steel stairs. That was not
The topping on the stairs, you mean the primer and paint, or what?
Yes, Your Honor, and also the finishing work for the fabrication.
Okay, what was the defect in the finishing work? Did they use the wrong? Did they use the wrong product? Did they apply the product incorrectly? What was the defect?
I believe it was the finishing work on it, Your Honor. So it needs to be taken down to a level where there's no rust. So I believe that's
The finishing work, meaning the coating that it was. You mean as I understood it, these steel stairs were supposed to be primed and painted, and I assume there was a specification for the primer and the paint. Is it your contention that they used the wrong product to do that, or that they applied it incorrectly? And if so, where's the evidence of that in the record?
Your Honor, and I think before you get to the painting or the priming, it is the preparation before that is applied, and
The preparation of the
the
steel.
preparation of the stairs. That
Okay,
needs to be
so they didn't, were they supposed to wash it with a chemical compound or treat it with a rust inhibitor and failed to do that, or what are we talking about here?
Your Honor, I would have to refer to the initial brief, which has citations.
Well,
to
see,
various reports.
if I had been able to glean this from the initial brief, I wouldn't be asking you the question. And one of the issues that you all want us to address in a comprehensive way is whether these defects were latent or patent, as I understand it, if the 4-year statute applies, which you argue it does, and I tend to agree, then I got to look at what the defects are and decide whether the trial judge erred in making a determination that they were patent as opposed to latent, and I really can't do that unless I know what the defects are. So I'm not getting a lot of help on identifying what the defects are.
Right, Your Honor, and I can, as I stand here, only refer you back to the references to the plaintiff's expert reports.
So if I went down the other list of subcontractors, you wouldn't be able to give me any more help than that? In other words, the stucco, J&S and S&R were involved in stucco. Now, the trial judge appears to have made a finding that there weren't any defects in the stucco. Is that right?
Your Honor, the trial judge applied the wrong statute of limitations, so we're talking about 9511-2B. Trial court found that there
Well,
was
the trial
no...
judge applied one statute of limitations as to the breach of contract count and one as to the violations of the building code, right?
Correct.
Right. So let's just assume that he was wrong about that and that he should have applied the 4-year statute on both. Then I got to analyze this from the standpoint of whether there were latent defects or patent defects, and how am I going to do that analysis
Your Honor,
on this record?
In this fashion, Your Honor, the project was complete in October of 2005. So CBC, from its perspective, leaves the completed project, and this is after the architect's filing of a certificate of substantial completion, stating that the project was complete, ready for its intended use.
So you're saying if this court concludes that the 4-year statute applies, then I don't even need to get into the issue of latent versus patent defects?
I think that's a jury question, Your Honor. I think that there is sufficient evidence in the Delta report.
That's what I'm trying to find out. I mean, this is summary judgment, right?
Understood, Your Honor, but
I'm trying to find out what the evidence is that you're saying makes a jury question out of it. The trial, for example, on the stucco, the trial judge decided that there were no he said that the record reflected that there were no defects. What am I supposed to do with that if you can't tell me where in the record there's some affidavit or something that shows that the stucco people performed defectively, either installed a defective product or didn't follow the proper construction sequence or procedures?
Right, Your Honor, I would refer you to the testimony of Robinson, the
Who?
Robinson, the WHI report.
Robinson? Okay.
And I would refer you to the top report, which summarizes the findings and the observable defects found by the various experts.
What did Robinson say about the stucco?
Your Honor, I believe it was with respect to the lathe ties that are part of the stucco work that were not properly installed.
So that's J&S, though. What about Simpson and Reba? I thought that Robinson and Zetterlund didn't say anything about Simpson and Reba as it related to defects. If they did, and I missed it, if you could point me to the record on that, I would be grateful as well.
And Your Honor, again, as I stand here, I don't have those details written down. I would have to go through the brief and to the various record citations to the expert reports identifying the defects in the stucco. And then there are cracks throughout the stucco work, water intrusion because sealants were not properly installed. And I think that's in the Delta report. It's in the MEC construction report.
But the lathe ties are J&S, right? Is the lathe ties, I didn't see that being Simpson and Reba, unless I missed something.
And Your Honor, as I stand here, I thought it was across all of the stucco work. I mean, there is certainly alleged defects throughout those expert reports. And I think whether that is patent or latent, whether those defects are patent or latent, is a jury question. And Your Honor, I believe...
Does it make a, do we view that issue through the lens of the owner or through the lens of the contractor? In other words, the owner comes in and sees a finished stucco product, but a contractor is supposed to observe the construction sequence and the manner of construction and determine before the stucco is slapped on there that, you know, that the ties are properly spaced and properly affixed. So when we're looking at latent versus patent, whose lens do we look through?
I think you look at it through the contractor's perspective. Now,
Okay.
for the owner of the property, they received the Delta report in January 2009, a final draft in April 2009. That was never provided to us. We left the completed project.
But I mean, just on the issue of the ties, I'm no expert in construction, but I thought the ties were what are fastened to the structure, so, and then they're integrated with the stucco, so it keeps the stucco from sheathing off at some point in time. It fastens the stucco. I mean, if we're talking about whether that's a latent defect through the lens of the contractor, and the contractor has a duty to supervise the construction, isn't it, as a matter of law, shouldn't the contractor have known that there weren't sufficient ties, or they weren't proper ties, or that the ties were not installed altogether?
Your Honor, I think that exaggerates the role of the general contractor. And I know that the appellants have made arguments that because of the managerial or supervisory role played by the general contractor, and it's set forth in a couple of statutes, that the general contractor cannot therefore take advantage of common law indemnification, that the general contractor...
Well, I'm just talking about the contract count now. I'm just trying to wrap my head around that. Your client filed an affidavit that they didn't know about any of the defects, okay? But that doesn't end the inquiry. It's an objective standard, right, whether they knew or whether they should have known. And should have known is an objective standard, if they're duty bound to supervise the construction, how can they get around that?
Your Honor, I think it's a jury question. I don't think the general contractor's role negates that it is a difficult factual question. There's no question that there are observable defects reported by these experts. There's cracks in the stucco, there's rusting, there are beams that are askew and sagging. The general contractor does have a general supervisory coordinating role to play, but the general contractor does not have the expertise for all these particular fields of work, which is why we hire independent contractors who hold themselves out and warrant in the agreement that they have the expertise, that they have the skilled employees that the general contractor doesn't employ, and that they will follow appropriate standards in installing this work.
So if a defect is latent to the owner, by definition, is it latent to the general contractor, or can there be defects that are latent to the owner? Build me this building or build me this house, but can be patent to the general contractor who ostensibly has some knowledge in how to build these things correctly, even if they have to sub.
I think the owner is in a better position. After the completion of the project, the general contractor, the subcontractors leave the project.
Well, that's kind of what Judge Torpey's asking, though. You seem to say it's a jury question, but can it be patent for one and latent for the other?
Absolutely.
Okay,
Yes, it
and
can.
so why isn't it patent here as things were being built and they're being built wrong across the board, according to what's going on here?
Well, Your Honor, it was not manifested at the time we left the project in October 2005. Those defects were not manifest. And again, I take you back to the architect's certificate of substantial completion, which found 0 defects. The defects don't start to arise, apparently, until 2008. They start manifesting themselves in the stairways. And we have no notice of that until May 2012, when a notice of claim is filed or submitted to CBC. So yes, I think it's the same test, whether it's patent or latent, but the owner is on the property, the defects start manifesting themselves after we have left the property, and we don't have notice of it until a subsequent time. There were 4 cross-claims brought here. I think that the contractual indemnity one is the first one that warrants the court's attention, in that the trial court found that the language of the indemnification provision, and there was a common language throughout these subcontracts, implicated 725.06. And specifically, the key language was that the subcontractor's indemnity obligations hereunder shall apply regardless of whether or not the claims are caused in part by a party indemnified hereunder. And it's that last snippet of language, are caused in part by a party indemnified hereunder, that was the focus of the dispute. And the trial court found that under that language, CBC was seeking indemnification for its own negligence. We don't agree. We think that language, are caused in part by a party indemnified hereunder, doesn't superadd to the indemnity obligation of the preceding sentence. It merely states that the indemnity obligation is not negated by some fault on the part of the general contractor.
Do you agree under contractual indemnity you're not entitled to recover for the active negligence of your client against any of these subs under 725.06 because you didn't comply with that statute? Or the contract doesn't comply with the statute?
To take that apart, Your Honor, we agree that we are not entitled to indemnification under this indemnification provision for our own negligence, and it wouldn't be enforceable under Florida law.
Right.
Our position is 725.06 does not apply because, in fact,
Passive negligence.
I'm
To
sorry.
passive negligence, you're responsible to the owner because your subs did something.
Correct. So we are not, and it sets up a comparative fault analysis, and we think this court's decision in Camp Dresser is precisely on point, in where this court looked at the exact same language and described it or agreed that it was a paradigm of clarity, citing to a United States Supreme Court decision. And the court also quoted the AIA comments. Then this is standard AIA language, that it does set up a comparative fault analysis, and this court stated that it covers the indemnity's loss only to the extent that it was caused by the indemnitor. And this court then ruled, we conclude that this provision clearly expresses the party's intent that CDM may be indemnified by Howard, even if CDM is sued for its wrongful conduct. So we think that the Camp Dresser decision is directly on point, and that was the basis for the summary judgment on the contractual indemnity claim, was the application of 725.06. In Camp Dresser, this court said that 725.06 does not apply to that language. This court's decision in Kuhachi is also on point. Kuhachi examined the same snippet of language, caused in part by a party indemnified hereunder, and found that 725.06 did not apply.
Well, does it make any difference that in Kuhachi, the parties seeking indemnification had already been exonerated of any negligence? They were just going after their fees in that case, right?
That's correct, Your Honor.
Or having successfully defended the claim.
They had successfully defended Kuhachi. It was you had a designer, you had the general contractor, and the designer successfully defended the negligence claim and then went against the contractor for the attorney's fees spent. And I don't think
your
it makes a
opponent
difference.
seems to think that that's a distinguishing fact. Do you think it is, and why not?
I don't, Your Honor. I think for this reason, in that the court looked, the decision is a bit opaque. I think it stands for one of two propositions. Either that snippet of language does not implicate 725.06, as this court would find 6 years later in Camp Dresser, or it was the stipulation or the fact that indemnity for negligence as opposed to attorney's fees was not being sought. And I noted that one case cited to, it was the Great Divide case, the Southern District in 2018, cites to Kuhachi for the proposition that it's a stipulation that we are not seeking indemnification for our own negligence, and CBC is not. We have never pled or argued that we're entitled to indemnification for our own negligence. So, Your Honor, I understand the additional fact there. I don't think it makes a difference in terms of what that language means with respect to the scope of 725.06. And I think we're in the same position in that we are not pleading or attempting to argue for indemnification for our own negligence. Of the 4 cross claims, the second was the common law indemnification claim, and we've touched on that. The trial court's focus was on the second element. The trial court found that there was no special relationship between CBC and the subcontractors, such that the liability or potential liability was vicarious, constructive, derivative, or technical. And the court was focused on this court's Affolter decision. And we think Affolter is distinguishable. Interestingly, it comes from the same dispute that would give rise to this court's Camp Dresser decision, in that you had Orange County as the owner, you had Camp Dresser or CDM as the designer engineer, you had Howard as the general contractor, Affolter, Waters, and it's a Waters employee that's injured, sues CDM, sues Howard and Affolter. Howard and Affolter get out on workers' comp immunity, CDM settles and goes after Howard on contractual indemnity, and that's your Camp Dresser decision. Affolter deals with Howard trying to get common law indemnity out of Affolter, and there was a legal bar to that. It was a personal injury claim, an injury suffered by a worker, someone working for an independent contractor. So there was no way for that personal injury claim to get up to Howard, and it was on that basis that this court found that there was no common law indemnity claim in that instance. The trial court seems to have read that as stating that anytime there is independent contractor status between the indemnitor and the indemnitee, that it forecloses common law indemnity. And we just don't think Affolter can support that proposition. With respect to the second prong, some of the contractors have argued that the general contractor's liability is inevitable, given the supervisory or coordinating role that a general contractor plays. And that strikes us as a sea change. If there is a bright line rule that's to be made stating that a general contractor, because of these Florida statutes, cannot bring a claim for common law indemnity against subcontractors, that's contrary to a lot of decisions that are already in the books. And if that's a bright line rule, then we need that guidance. But we don't think that there is a valid argument that a general contractor is inevitably at fault. Rather, we think that that is derivative, constructive, technical, and falls within the special relationship that can give rise to a common law indemnity claim. The first prong, I think, is easily resolvable. It's premature to say that CBC was at fault. The first prong is that the party has to be wholly without fault. It may be difficult in some of the claims, but you've got defects here in these expert reports from soup to nuts in terms of issues at the property. And to say that we are at fault for those or have active fault, I think is something that can't be resolved on summary judgment, but has to be delayed to a jury determination. Wanted to touch on the breach of contract claim. And again, these are issues that are common across all of the appeals. There were legal decisions made by the trial court on the contractual indemnity, the common law indemnity, and the breach of contract claims that are common to all of the appellees. Here, in the breach of contract claim, the association brought Florida Building Code violation claims against these subcontractors. We, in turn, brought cross claims against these subcontractors. When the trial court dismissed or the claims from the association against the subcontractors, the trial court also determined then that the cross claims that we had filed under 1.170 were converted into third-party claims under 1.180. And with summary judgments granted on contractual and common law indemnity, those claims had to go. The relevant amendment to 1.180 has been in place since 1984. There's no authority supporting that conversion. And I think it's at odds with the rationale for 1.180, which is that a defendant shouldn't be able to bring a stranger into a lawsuit without some underlying connection to the principal or underlying claim. And that's a rationale that doesn't really have any purchase here. So we think the trial court got that conversion wrong. And also, if the court grants relief on the contractual indemnity or the common law indemnity claims, that obstacle becomes moot. And, Your Honor, we've talked about the statute of limitations. With respect to the breach of contract, the court found that 9511(2)B applies, and we think that's fairly clearly wrong under the case authority, including this court's decision in Brock. This was an action founded on the construction of an improvement to real property. It's a 4-year limitations period with tolling provisions for latent defects, which returns us to the beginning of the argument, Your Honor. The trial court's focus was on the statute of limitations and the wrong statute of limitations. We think if you look across those reports with respect to the numerous defects alleged, which are all over the scope of work performed by these subcontractors, that it becomes a jury question as to whether those were latent or patent to a general contractor that left the project in 2005 with no indication, no manifestation of problems, and no notice of anything going amiss at the property until 2013.
Counsel, can I bring you kind of full circle to Judge Torpy's initial line of inquiry? If the trial court determined that there were no genuine issues of material fact as it relates to the existence of defects as it relates to certain of the subcontractors, assume we do see it your way on the indemnity claims, what's left to pass through?
I'm pausing, Your Honor, because I'm not fully understanding the.
So when you ask
nature
somebody
of the
to
question.
indemnify you for something, you're
Correct.
saying, hey, I don't necessarily concede that I did anything wrong, but if I did, it's that guy's fault.
Correct.
If you've already got a trial court ruling that that guy didn't do anything wrong, and there's no record evidence to contravene that, what's left to pass through?
Well, Your Honor, this lawsuit is ongoing. There is a second amended complaint that makes all of these claims, that alleges that all of these defects were latent. The trial court denied summary judgment to us on the very same arguments. The trial court found that there were material disputes of fact with respect to whether these were patent or latent defects from our perspective. So we're still in this lawsuit, which is, as I said, ongoing, and I see that I'm down to
Yeah,
5
you're into your
minutes and
rebuttal
20
time. If you want to keep going, you can stop, or,
I will stop there and come back.
Okay.
Thank you, Your Honor.
all righty. Okay, hang on, counsel.
May it please the court,
All right,
Carol
just
Rooney
hang-
for the Appellees.
Just hang on just a second. Okay, so I'm gonna, the clock's gonna go to 30, so I'm gonna give you a heads up when it's at 15, okay?
Thank you, Your Honor.
All right.
Carol Rooney for JS Plastering and ALLENS Steel. Your Honor, I think it's important to start out with an overview of what was happening at the time that Judge Roberts granted these motions for summary judgment. We were literally on the eve of trial. The case had been crystallized at that point. We were operating under a very specific case management order that required the disclosures of expert opinions and reports, so everybody was on the same page as to what was going on. So I think it's important to keep that context in mind as you're reviewing this. And essentially, this case was one of contractual indemnity. And without question, the statute was triggered by the way that provision was drafted. Even if you compare the language of the contractual indemnity provisions, and I believe they were all virtually the same as to all the subcontractors, it says, the subcontractor's indemnity obligations hereunder shall apply regardless of whether or not the claims, damages, et cetera, were caused in full or in part by the contractor. That's basically saying whether you're responsible for your own scope of work, even if the contractor also had some fault in whole or in part, we would be that arguably entitled to or required to indemnify the contractor. So that means you have to look at 725.06. The statute was triggered. So Judge Roberts correctly ruled that the statute was triggered, and then he concluded correctly as well that they had not complied with the statute that requires a reasonable monetary limitation on the indemnity. Now, the compliance issue, my opponent has not even challenged that on appeal, so that's not even up for grabs. So without question, the statute was triggered by the indemnity provision. Turning now to the remainder of the causes of action, common law indemnity.
Well, hold on, let's talk about the contractual indemnity. What do you say about our Kuchachi, I think it is, case, and then the other case that counsel addressed a little earlier? What do you say about those cases?
I don't don't think those conflict with our analysis at all. In fact, if you look at the exact language in Camp Dresser, and it is a little bit different because they had carved out, except for our responsibility.
You
or
think the
liability for-
distinguishing feature is the language in the indemnity clauses in those cases? You think that there's a distinguishing feature based upon a difference in the language of the indemnity clauses? Is that what you're saying?
That's part of it, because they certainly are more specific where they carve out, except for our preparation of plans, et cetera.
That's pretty subtle.
It's pretty solid, so.
No,
I
it's
mean,
pretty subtle, I said.
It's subtle, but then also.
If that's your strongest argument, that one's probably not going to work with me. What's your other argument?
That's not my strongest argument. My strongest
Okay,
argument
let's get right to the strongest argument.
My strongest argument is the court recognizes, this court recognized that the language used, which is virtually identical to ours, did contemplate indemnity for the contractor's negligence. So once you contemplate that that's
Right.
negligence is involved, then you've triggered an analysis under the statute.
Well,
It's not-
but that doesn't throw out the entirety of the indemnity clause, right? The statute doesn't, the statute appears to only throw out invalidate the portion of the indemnity clause that provides for indemnity when the indemnitor is at fault.
The statute requires, if the statute applies, and the statute applies any time that a contractor is seeking indemnity for its own fault, which can include concurrent fault, which overlapping fault, and there's cases that have come after the Camp Dresser case that talked about that. And when you have language that says shall apply.
What is your best case that you are relying on for the proposition that when you apply the statute to the indemnity clause, it essentially invalidates the entire indemnity clause?
I think the best case, Your Honor, would be, I believe it's that ATO case.
What's it called?
ATO is part of the name, but there is case law that talks about you can't just parse and once you determine that the statute applies, then you have to see, well, was it complied with? So if we agree that the language in the statute, and I think this court agreed in Camp Dresser that it certainly contemplates that if the contractor is liable, you may be responsible for indemnifying the contractor regardless of the contractor's fault. And then the court went into this comparative fault analysis, but clearly the language contemplates that you are going to be responsible for indemnity notwithstanding or even if the contractor is at fault. But once you have that language, 725 says any time that you're requiring indemnity for something that's just beyond purely something that you do that contemplates any other party's action, then the statute applies. And once the statute applies, you have to say, well, have we complied with the requirements? It's not just a matter of carving out bits and pieces and saying, well, we're stipulating, we're only seeking indemnity for what you did. I think Judge Roberts hit the nail on the head when he said, no, it's not what you decide to do later, years down the road, based on claims that are made against you. It's like, did this provision comply with the statute at the time it was drafted? Because the parties are negotiating at arm's length. We're trying to allocate, the allocation of risk and loss. So you have to decide at that point, does this comply or not? It's not based on anything that might happen subsequently down the road. So that's why I think Judge Roberts was correct.
And you have a precedent that says that somewhere in your briefing.
I'm sure I do, but I think that's just general principles of Florida law under contracts. I mean, when you evaluate under Florida law, when you evaluate a contract that's subject to a statute.
Well, we start with the statute, right?
Yes.
That talks about the word portion. If all or a portion of the indemnity provision does this, then this is the consequence. And we've got some cases out there that say, what that means is that the indemnity clause is only trumped to the extent that the portion of it allows for indemnity for the indemnitor's own active negligence, right? Isn't that what those cases seem to say?
True, Your Honor, but we also, but that's if you can.
And your
legally-
counter to that is the
You can't always.
argument that if it was invalid, if it was invalid to begin with, ab initio, then their decision to only pursue a particular claim doesn't revitalize the invalid contract, right? Do I understand your argument?
That is correct, Your Honor. And also, that doesn't contemplate the fact, which often happens in the construction context, is that there could be concurrent fault. It's not as simple as just saying, well, your fault's over here and my fault's over there. Many times it's overlapping and concurrent. And if that's going to be the standard, how in the world is a party ever going to be able to properly negotiate and allocate risk? It's like if any portion of the other party's fault is commingled with yours, then you better have a contract that complies with 725.06, because you're not going to be able to sort that out later. You need to be able to sort that out at the time you draft the contract. And that was the problem with this agreement. And also some of the other issues that have come up, you were correct, Your Honor. As I mentioned earlier, we were at the eve of summary judgment, or at the eve of trial. And as far as the...
Who was correct? Me or Traver?
Your Honor, were you...
Oh, I didn't know I was making any assertions. I thought I was just asking questions.
Yes, Your Honor.
Yeah.
And-
I was correct about
But the
what?
point that you were making, what I think was accurate, that at the eve of trial, we were operating under a very specific case management order, and literally no specific defects had been alleged, no building code violations had been alleged. And we had actually the experts that the CB Contractors was relying on, and he stated quite clearly at the hearing on the motion for rehearing that they were relying on the association's experts. And the only a defect that was, or not even a defect, the only issue related to the staircases was they were rusting, they were corroded. And that was obviously...
Did the plans call for concrete or did the plans call for steel?
The plans called for concrete, but again, our contract, I mean, whether the stairs were concrete or steel, I mean, surely when you provide steel staircases, that's obvious to the contractor, and they accepted the steel staircases. So, but it's our understanding that the plans called for concrete.
Was there some allegation somewhere, I seem to have a vague recollection, that the wrong product was applied, or it was applied incorrectly, and that was the reason for the rust? I mean, we all know steel rusts, but I thought I read something that these were supposed to be primed and painted, and that there was specifications for the primer and the paint, and that they didn't do that correctly. Is that allegation in there anywhere?
My only recollection is the issue with corrosion. And again, I'm referring to like the top report, Mr. Robinson's testimony, and it was the rusting and the corrosion. And then we relied on our scope of work that was set forth in the subcontract that was fairly limited. And so basically, based on that evidence, that's what Judge Roberts relied on when he said that the statute of limitations, regardless of the 5-year or 4-year, at least until for the staircases, the metal staircases.
But they can still sue for indemnity, right? I mean, assuming that Judge Roberts is wrong about his analysis of 72506, regardless of whether there are defects in fact, there's a suit by the owner against the contractor, and the contractor says, hey, we don't think we're liable, but if we are, we're going to pass it through to them. I mean, that's what indemnity is all about. It's not, if the record reflects at this point that there's no defects, that doesn't trump the indemnity claims, right? Only the breach of contract claim.
If there was a valid contractual indemnity, absolutely. And we did point that out to the court, that they could have had a valid contractual indemnity provision that was completely outside of the statute if they just changed one word. Instead of regardless, unless. One word change, and the statute wouldn't have even applied. So the summary judgment was appropriate in this case based on the record that was developed or not developed by the parties on the eve of trial. And that same issue applies to the building code count. Here we were on the eve of trial, and not a single building code violation had been alleged or identified. as to JS Plastering or Allen Steel. And I believe my colleagues will tell you the same thing. Never, even on rehearing, no building code violation identified or alleged. Even today on appeal, of course, you can't bring up an argument like that first time on appeal. But even as today, we don't know a single building code that's been alleged or identified that my clients violated. So Judge Roberts correctly granted summary judgment on the 553.84. He correctly granted summary judgment on the contractual indemnity provision. He correctly granted summary judgment on the breach of contract. And we did argue, I would point out, that the breach of contract cross-claim was virtually identical to the contractual indemnity. Counsel admitted that they were really seeking indemnity damages. So you can't get around an invalid indemnity provision by suing under a breach of contract. So Judge Roberts correctly agreed that we were entitled to summary judgment as to the cross-claim for breach of contract. And that leaves us with common law indemnity. And again, common law indemnity, that's an equitable remedy. And I know Florida has not exactly addressed this yet, but certainly when you have a contractual agreement as to indemnity, and then you have a statute that basically says what agreements are enforceable and not enforceable, I don't think a party should be able to rely on some common law equitable remedy to basically get around an invalid contractual indemnity provision and all the other problems with the case. And again, here, CB Contractors was not sued for
I didn't get your legal argument there. That one eluded me. So you're saying that common law indemnity can't be used if the contractual indemnity provision violates the statute? Was that your argument?
It sort of defeats the purpose of even negotiating a contractual indemnity to agree with, to begin with.
Well, I mean, if you're right that it invalidates the contract, all that means is that the contract goes in the trash, at least the indemnity part, right? I mean, why does that vitiate the common law remedy of indemnity?
Because the common law should really only step in when there is no remedy at law. When
Yeah,
there
well,
is no.
there wouldn't be if the contract provision was invalid, right?
Well,
Right.
that the whole point of even having a statute is basically to give parties an idea, this is what you need to do. If you have this kind of contract, you need to comply or not comply. The Florida legislature has spoken on the issue. So if the Florida legislature has spoken on the exact issue, why are we looking to a common law equitable remedy? But even more importantly.
You're coming up on your 15 minutes.
Yes. Even more importantly, Your Honor, is the fact that without question, CB Contractors had active, non-delegable fault. They were sued for a breach of warranty, not negligence. So we respectfully request it, Your Honor, and for the trial court's ruling.
Okay. Who's next? Looks like the last one down the line is going to get stiffed here. Huh?
It happens.
May it please the court?
Yes, sir.
Esteban Skornick on behalf of Saxonis Custom Painting. And Your Honors, the one point that I would really want to stress on behalf of Saxonis is what we've been talking about as to the lack of summary judgment evidence under Rule of Civil Procedure 1.510, creating an issue of fact as to any alleged defective work of Saxonis Custom Painting. And Your Honors, when we filed our motion for summary judgment, we also filed the affidavit of our expert, Stuart Gregory, in support of our motion. It's beginning in the record on page 5637. And Mr. Gregory, in paragraphs 6 and 7, stated as follows. In Mr. Gregory's opinion, Saxonis did not perform any defective work or provide any defective materials on the property. Saxonis's work was in accordance with plans and industry practices, and its work did not violate the applicable building code. Paragraph 7, even if there had been any construction defects associated with the work or materials of Saxonis, any such defects would have been readily observable and discoverable by CB Contractors. And so, Your Honors, in the context of a motion for summary judgment, what
Did the trial judge make that finding as to your client, that there was no evidence to controvert that assertion in the affidavit?
Well, Your Honors, there are two orders, one on counts one on contractual indemnity and common law indemnity, where he did not mention that in the order. On the other two counts, the violation of building code and breach of contract, the order specifically says no finding of any fault on the part of Saxonis. So partially, the answer is true.
All right, and I asked counsel this, and I think she conceded that the lack of a defect or lack of defective performance in and of itself does not negate the indemnity claim. Do you agree with that?
Not necessarily in our case, and let me tell the court why. There's an extra sentence in our contractual indemnity clause that I'm not sure is in with respect to the other subcontractors. The last sentence of that first paragraph as to contractual indemnity as to Saxonis states, this paragraph applies only if this subcontractor is negligent in his performance as it pertains to the contract. So
How about common law indemnity?
well, common law indemnity, of course, one of the elements of common law indemnity is not just that the indemnity is wholly without fault, but that all the fault is with the indemnitor. So we're at summary judgment stage. I would assert that when there's a complete lack on a summary judgment hearing as to any fault.
Well, the Kachuri case that we decided was a case just like that, where there was no fault by either the indemnitor or the indemnity, but the indemnitor still had a claim for defense costs that was properly asserted, right? I mean that happens. You might be right, which means they're right about the painting. You're the painting guy, right? Painting?
Correct.
Yeah. You might be right. They might be right. The association may lose, but that doesn't mean that they don't have a right of common law indemnity, does it?
Well, it would seem to me when I read the elements that are required for common law indemnity to apply, and not disregarding the other cases that the court has mentioned, it seems to me that if there can be a finding...
I mean, they can keep you in there till the end, right? You can't get out on summary. They keep you in there until the jury decides whether whether the association is correct vis-a-vis the painting subcontractor.
But I guess that's the issue, Your Honor. Is it a question that if there's nothing in the record of fault, are we stuck until trial?
Well, if there's nothing in the record of fault as it relates to your client, then the association's going to lose on summary judgment, right? I mean, they've got to come forward with some evidence that there was a defect in the painting work, right?
And I don't want to lose my time because I know I've got others wanting to talk. But I guess my last point
Well, you brought up the issue, so, all right.
I'm sorry. No,
Okay.
absolutely.
All right.
My last point on this is that we're here now on an appeal on summary judgment as to the claim against us. You know, I would submit that we shouldn't have to wait what happens down the line with the association's claim. CB Contractors could have submitted an affidavit from someone from the association's case if they wanted to. Submit something to oppose our motion. It didn't get done.
All right, your
Thank you, Your Honor.
5 minutes is up. Okay, next.
Good afternoon, Your Honors. Sarah Lalu Amin on behalf of Ferris Floors, and may it please the court.
Okay, go ahead.
Your Honors, with respect to Ferris Floors, I'd note that on page 16 of the initial brief, that the appellant concedes that Ferris Floors, there's no evidence whatsoever of a defect that the expert they relied upon could point to. And with that concession in place, while there may have been notice of a defect, if it was a defect, it was open and obvious, it was a patent defect. But it's up to them on summary judgment to connect those dots and say this issue with flooring is based on a defect that is the fault of Ferris Floors. And they didn't do that on summary judgment. They did not carry that burden in opposition. And so for those reasons, the court was absolutely right in entering summary judgment. And to Judge Traver's point, with respect to indemnity, if we don't have evidence of a defect, ultimately, there's nothing to pass through. So that adjudication has already been made. And with that adjudication in place, we know
Is that adjudication binding on the association?
Well, the association is certainly involved in this action. The association is a party. The association has a voice, and that
They're not here today. Are they bound by the summary judgment's finding that Ferris didn't do anything wrong?
Your Honor, that's a question that would certainly require careful analysis by this court and making a ruling to that effect if that were necessary. I believe that issue would be res judicata after this appeal, would be law of the case. I don't see why not. They're involved in this case. We were on the eve of trial. It was up to them. It was up to...
They weren't, a motion for summary judgment was not directed to their claim, right?
Wasn't directed to their claim, Your Honor, because their claim had been dismissed. So they had actually...
No, their claim against the contractor for the component of the claim that related to the work that your client did.
Correct, Your Honor.
That claim was not extinguished at summary judgment, was not disposed of.
No, it wasn't disposed of. And that claim, it's important to note as well, is against CB directly for something that cannot be against Ferris, for something that cannot be against the subcontractors. And so no matter whatever happens with the association, it's going to be one of two things. It's going to be that the association is deemed without fault, well, then there's no indemnity. Or it's going to be that that CB Contractors is without fault and therefore there's no indemnity. Or it's going to be that CB Contractors does have some fault pursuant to that claim, and that claim is against CB Contractors. That claim cannot be made against the subcontractors, and no claim stands from the association to the subcontractors. So no matter what, the general contractor's fault is implicated here, which would preclude on both indemnity claims any liability.
Was the main action still pending against the general contractor by the association for the various defects that the GC is now trying to pass off onto the subs?
Yes, Your Honor, and initially the association sued the individual subs as well. And with respect to Ferris, and I believe the others too, those have been dismissed.
Right. But they're still trying to say, okay, whatever we bought is defective. GC, you and I have a contract, so you need to fix it, and we want the jury to award money for all these defects. And GC wants to have the jury come back and say, no, there's nothing wrong, but in the event, and if it comes back there's nothing wrong, they're still going to want to seek defense costs against your clients, right?
Well, if there's nothing wrong, then there's nothing, there's two requirements. They have to be without fault. We have to be with fault. And so if there's nothing wrong, we're not with fault. But getting to the bigger question of whether there's just simply no evidence to support it, and that was the issue that was teed up for the court on summary judgment, is whether there is any evidence. So that issue came to be decided by the court. It was on the eve of trial. All of the evidence that anyone would have had to support a defect, to support anything that could be passed along, breach of contract, building code violation, or indemnity. All of that was before the court. They had their opportunity, and they failed to carry that on summary judgment, and the court properly entered summary judgment. And we respectfully request that the court affirm.
Okay. You saved 5 minutes on the nose for your final colleague there. It's pretty good time.
Good afternoon, Henda Klein here on behalf of Simpson and Reba. We essentially stand in the same stead as Ms. Rooney's client, and unless the court has any questions related to the claim against Simpson and Reba, we really have nothing to add.
Okay. All right. Thank you, counsel. All right, counsel, you have 5:15 on rebuttal to all the various.
Your Honor. Let me first address the contractual indemnity claim in 72506. Counsel stated that if just one word had changed from regardless to unless, then the provision would be enforceable under 72506. In Camp Dresser, this court looked at that exact issue It is, again, standard AIA language. Here's the language I'm reading Camp Dresser, regardless of whether or not it is caused in part by a party indemnified hereunder. Camp Dresser is right on point. It is dispositive of the non-application of 72506 to this indemnity provision. So the indemnity, the contractual indemnity, should be reversed on that basis. With respect to several arguments that there was no finding of fault, for Saxonis, there was no finding. The issue was never addressed. There were not many trials and summary judgment on whether or not there were defects below, and we're conflating two things here. The experts across the board found defects in the property. On the Florida Building Code violations claims, the plaintiff experts never cross-referenced or came up with the exact Florida Building Code violation claim. Not aware of authority that says if you have a defect but no clear or no express tie to the FBC at the summary judgment stage, that the claim is gone. But it is not a finding of no fault, no defects. It was simply summary judgment granted, or at least an argument made, that the FBC code provisions weren't identified by the plaintiff experts. Your Honor, I want to come back to, but I want to be very clear. There was no finding in any of these summary judgment orders that there were no defects or no fault. It was the summary judgment.
Well, I thought as to Ferris, the trial court found there was no evidence of defective performance. Am I wrong about that? I've got that in my notes, and the trial judge affirmatively found there was no evidence of defective performance by Ferris. Is that not true?
Your Honor, I don't know that that's accurate. I think that the trial court's decisions were premised on...
Counsel cited page 16 in the brief and said y'all had conceded that. Is that...
Okay. And I don't know which subcontractor...
Guess I got to look at page 16, huh? That's all right. Okay.
Your Honor, I did want to point you to the record.
And their other argument was that when confronted with an affidavit that says we were not defective in our performance, that you had the burden to somehow either refute that, and you didn't want to refute that because you agreed with them on that, or somehow force the association's hand by moving for partial summary as to that component of the association's claim. What do you say about that? I mean, you're in the middle, so you don't want to take a position on the defects one way or the other. I get that. But if they're trying to get summary and they have evidence that they didn't defectively perform, it seems that they should be able to get out of the litigation without having to go to trial if they've, if there's no evidence coming back the other way.
And Your Honor, if that were the case, we'd be extremely happy if the trial court had made the determination that there were no defects.
Well, but I mean, you didn't ask the trial judge to do that. You could have, in light of their affidavit, you could have moved for partial summary against the owner as to that component of the owner's claim and taken the floor topping contractor out of the equation. Did they seem to suggest that you had some duty to do that, because you could end up in inconsistent positions. They come in with an affidavit and say we didn't do anything wrong. You don't refute it because you don't want to obviously admit there was any wrongdoing, and then you go back and trial again, and the association proves that there was a defective work by that sub.
Your Honor, CBC is definitely in an unenviable position in this regard.
But it's not a position that a general contractor finds unique. I mean, it's a pretty run-of-the-mill scenario, really.
Correct.
You don't think you had the burden to force the issue by filing a motion for summary judgment against the association on the liability of that subcontractor? Is that what you said?
Your Honor, I think we were relying on the plaintiff's experts. So we're relying on the MEC, the TOP, the Delta, the Wagner report. And I did want to point out, while I still have some time here, to 1655, 1656 in the record. And this is a summary in the top report of the findings. I'll read just one in my 14 seconds left. Failure of the stair supplier to properly prepare metal components by removing rust and cleaning prime or finish painting and the use of inappropriate paints are construction deficiencies. That's at 1656 in the record. Stucco, reported by Delta and MEC, includes stucco installation deficiencies, stucco shrinkage, lack of sealant, failure to properly install sealant at windows and through wall penetrations, and improperly installed flashing. So again, I would point you to the top report for the best of the, or at least a summary of the plaintiff's evidence of the construction defects that we are still litigating below as the general contractor.
Okay,
And
thank you,
I thank the court
counsel.
very much.
All right, thank you.
Thank you.